Hey everyone, this is Laura from TheRealLauraB here on YouTube and on Twitter, and I'm back today to start a new series in addition to my Unsealed series called The Battleground Leading Up to Fairfax. This is all the pre-trial battleground that Johnny had to endure to get his discovery into the courts in Fairfax. And believe me, it's extensive. And today I'll just be dealing with Warner Brothers in California, but I'll give you a little overview of what went on in California and how huge the motion work was there. So I'd like to start off with saying right now, when talking about what is a foreign subpoena, and it's not always what you think it is, but in our case, we're going to be talking about out-of-state subpoenas. So let's get started.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Okay, well, let's start off with how these out-of-state subpoenas work across our country. And we go to the American Bar Association, and it says UIDA, which is an acronym, and how it affects the out-of-state subpoena process for state cases. The Act provides a standardized means for litigants to take depositions and obtain discovery from individuals and entities located out of state. Now, for this, we're talking about out of state. Virginia would be the state where the claim was filed. Virginia is the home state. Any subpoenas that Johnny issued from the Virginia case to, say, California residents or businesses, New York City residents, businesses, or Washington, D.C. resident businesses are out-of-state subpoenas, or sometimes called foreign subpoenas. In an effort to streamline the onerous, time-consuming process of conducting out-of-state discovery for state court cases, the Uniform Law Commission developed the Uniform Interstate Depositions and Discovery Act, promulgated in 2007. The UIDA, or UIDA, has been adopted by a majority of states and provides a standardized means for litigants to take depositions and obtain discovery from individuals and entities located out of the state. The UIDA harmonizes the out-of-state subpoena process for state court cases and federal rule in Civil Procedure 45, based on the federal rule. When seeking out-of-state discovery in a state court proceeding, a litigant must first obtain a subpoena from the state court where the case is venued, Fairfax, Virginia. And we saw those subpoenas uploaded. Not all of them. We found out there were more hidden, but most of them were uploaded. The litigant must then present the subpoena to the clerk in the county in which the discovery is sought. Thereafter, the clerk shall promptly issue a local subpoena for service upon the person or entity for whom discovery is sought. It is important to note that the subpoena must comply with all state rules and statutes related to discovery, meaning it doesn't mean it has to conform to Virginia's rules. If they're serving someone in California, it has to conform to their rules. California is one of the states that I think you must serve in person unless the person you're serving is authorized their lawyer to accept service or something like that. But generally you have to do in-person service, although there's other steps after that. But the bottom line is whatever the judge rules in California, Virginia judge does not overrule. They follow whatever they've ruled. The UIDA repeals the law in those states where discovery is sought that still require a commission or letter rogatory from a trial court before a deposition can be taken in those states. Under the UIDA, a subpoena request does not constitute a court appearance, and therefore the out-of-state litigant is not required to be licensed in the state. Therefore, one does not need to be admitted pro hac vici or obtain local counsel when requesting a subpoena pursuant to UIDA. However, a local state license is required to file, respond, or appear in court related to an application to enforce, quash, modify, or obtain a protective order concerning a subpoena issued pursuant to UIDA. So Johnny Depp, Amber Heard, and many other people who were subpoenaed had their own lawyers in California. Those lawyers did not have to be licensed in Virginia because that's where the case was. They were arguing the subpoenas, for example, in California. As of 2016, here's the following states, and the ones that matter to us are District of Columbia, New York, and California. Where did I just see California? California, District of Columbia, and New York are the ones that affected Johnny. In addition, legislation to adopt the UIDA has been introduced in Arkansas, Ohio. It remains critical to check the requirements of both the state and locality where your case is venued and the state and locality where you seek conduct discovery, because some states have adopted slight variations and other states have only recently adopted it or will in the coming months. The state in which you are attempting to obtain has adopted UIDA. The process will be more efficient and less expensive than what it used to be. So let me show you what's happened in California. Amber Heard filed her first motion. Now watch your eyes. Amber Heard versus the Mandel Company, and here's our case number, and it started October 29th, 2019. Now, why does it say Mandel Company here? Hold on, watch your eyes. I've got to go to the bottom. And we have many, many motions, as you can see, filed. The first motion, she opened a civil case sheet wanting a petition and memorandum to enforce a subpoena. She was trying to force the Mandel Group to provide documents. Well, that was from a lawsuit that Johnny had done, but that was the first subpoena motion was filed. Because of that, that's how this case got named versus the Mandel Group. Although you will see many, many more have been added. Many other subpoenas have been come up. There's the Mandel Group. And there's many others that eventually get added in. I want to watch your eyes. A lot of these you have to open up to see them. I've purchased a lot of these, not all of them. Here's Jacob Bloom, Chris Carino, Tracy Jacobs, Jack Wiggum. I'm just going to name a few of these. Goodman Shankman is this is an omnibus petition that he was trying to block because they were excessive, over broad subpoenas. Miramax, Bruckheimer, Walt Disney. Walt Disney is an interesting one to cover. Stephen Deuters, Christy Dombrowski. Stephen Deuters was being subpoenaed here because he was working for Infinitum Nihil in California. So I think they were trying to serve him through the company. But anyway, watching your eyes, we're going to go forward a couple years, actually, for today's subject. Sorry, guys. You can see how much has been filed. It's crazy. All right. We're going to start on around February 23rd. It's even earlier than that. February 18th. So this is all this year, although this was initiated in November. So Warner Brothers has filed to quash their motion to appear as a subpoena for the deposition and for the documents in the subpoena. They filed to quash it. There was a declaration of their attorney. We have the opposition of Johnny Depp. It was 99 pages. We have the motion to seal portions of it. They lodged those motions. We have an ex parte application from Johnny Depp. You'll see that because the hearing was going to be after the trial. They got the hearing earlier in, and then we have our ruling. So I did not buy these pages, 77 and 17 pages together, because when we get Johnny's response, well, first of all, what I've learned from Emily D. Baker are motions like these are allegations with shade. They're throwing everything they can in there, and then Johnny's responds to it. So since he's responding, he's basically restating it. So to economize my page count, I just started with Johnny's opposition. And that's how we'll start today. See if I can make it a little bigger. Yes, it's 99 pages, but that because it includes a lot of the subpoenas. I'm not going to read all those. They'll be attached. But this was to be heard July 19, 2022 originally. Like I said, he filed an ex parte to get it moved forward, and they did hear and rule on it. These are his, he was represented by Samuel Moniz in California. So we'll just start off. Plaintiffs, John C. Depp, opposes the motion to quash plaintiff's deposition subpoena for personal appearance and production of documents or protective order filed by Warner Brothers Entertainment as follows. See, we're getting the introduction, so we didn't need all those pages. Warner Brothers' conduct in bringing the present motion is indefensible and warrants sanctions. The motion was filed without any valid basis in law or fact. for the improper purpose of running out the clock and on facially appropriate discovery. Moreover, the motion and the culmination of a series of questionable tactics on the part of Warner Brothers to pressure the parties to this action to abandon legitimate efforts to depose Warner Brothers by, among other actionings, threatening to say bad things about Mr. Depp and Ms. Heard, and otherwise threatening to testify about parties in a damaging manner. When those tactics failed, Warner Brothers filed this motion, effectively taking the extraordinary position that it is entitled to just ignore a subpoena. The court should send a clear signal that Warner Brothers is not above the law and is not exempt from relevant targeted discovery. The motion should be denied. Warner Brothers should be ordered to produce a representative for deposition, and sanctions should be imposed against Warner Brothers for its abuse of the discovery process in bringing this grossly improper motion. This is a defamation action brought by Mr. Depp against his former wife, Amber Laura Heard, on the grounds that she falsely claimed to be a victim of domestic abuse. In turn, Ms. Heard has brought a $100 million counterclaim against Mr. Depp, contending that she has suffered damages to her career as a result of 3 allegedly defamatory statements by a lawyer associated with Mr. Depp, Adam Waldman. Consequently, a major disputed issue is a case in whether Ms. Heard can credibly claim to have suffered $100 million or any amount in damages to her career. Ms. Heard is an actress whose roles included performing in Warner Brothers' major superhero films Aquaman, which preceded the counterclaim statements, and its sequel, Aquaman the Lost Kingdom, Aquaman 2, which postdates the counterclaim statements. Mr. Depp served subpoenas on Warner Brothers, which are attached to motion seeking documents, record subpoena, and testimony, deposition subpoena. And collectively, the subpoenas, relevant to assessing whether Ms. Heard suffered any adverse consequences from Warner Brothers as a result of the counterclaim statements. That's the only thing she's claiming on those 3 statements. Astoundingly, Warner Brothers' subsequent motion seeking to quash the subpoena is based on relevance, but the relevance of discovery sought by Mr. Depp is beyond any legitimate dispute. Now, both sides agreed to redact these. Given that she is claiming career damage in this action, Ms. Heard's role in Aquaman 2 is a major issue in the litigation. Of note, Warner Brothers counsel has represented in writing that Ms. Heard suffered no adverse consequence as a result of any statements by Mr. Depp, that any delays in picking Ms. Heard up for the role in Aquaman 2 was either non-existent or due to, quote, creative issues, quote, about Ms. Heard, and that Warner Brothers would never have renegotiated her salary. Warner Brothers has thereby conceded that Warner Brothers is in possession of directly relevant, discoverable information about Ms. Heard's lack of damages. She's claiming $100 million. She didn't lose any work. A deposition of Warner Brothers to explore those issues is manifestly appropriate. Yet bafflingly, Warner Brothers has refused point blank to produce anyone for deposition on the apparent grounds that Ms. Heard's claims are bogus and that Warner Brothers should not have to be bothered with testifying about them. While Mr. Depp agrees that Ms. Heard's claims are bogus, one of the basic purposes of discovery is to develop evidence to refute and disprove meritless claims. Warner Brothers is not immune from discovery and is not entitled to simply ignore the subpoena power of the court. The discovery sought by Mr. Depp is indisputably relevant and narrowly tailored and has been substantially narrowed in meet and confer process. The motion should be denied, and because Warner Brothers lacked substantial or any justification for filing it, Mr. Depp seeks appropriate sanctions. Here's a summary of the actions and the subpoenas. This is a defamation action pending in the Commonwealth of Virginia and is currently set to commence trial on April 11th. Mr. Depp commenced the action in March 2019 with filing of his complaint, which alleges, among other things, that during Mr. Depp's relationship and marriage to Ms. Heard was violent and abusive, once going so far as to cut the tip off of Mr. Depp's fingers, and falsely accused Mr. Depp of committing abuse, causing him significant career and reputational harm. Ms. Heard, in turn, filed a counterclaim asserting that she suffered $100 million in damages from certain statements disputing her truthfulness, reportedly attributed to Mr. Depp. In an effort to explore Ms. Heard's damage claims, because Ms. Heard is known to be attached to Aquaman and Aquaman 2 films, Mr. Depp issued and served a deposition subpoena and record subpoena on Warner Brothers. Thereafter, Mr. Depp's counsel met and conferred with counsel for Warner Brothers on a number of occasions in December 2021 and January and February of 2022. I believe the subpoenas were initially issued in November. Because Ms. Heard is still attached to the Aquaman projects, Mr. Depp agreed in December 2021 to accept initially a minimal production of documents from Warner Brothers. its contract with Ms. Heard, and further agreed to postpone a deposition of Warner Brothers persons most qualified, PMQ, until after Ms. Heard was deposed, to avoid burdening third-party Warner Brothers with a deposition that might prove to be unnecessary. However, it very quickly became apparent that a deposition of Warner Brothers is necessary. Now, I have no idea what this could be. Could it be something she claimed in an interrogatory? Could it be something she claimed in her deposition? I don't know. But it appears it's from her deposition. Shortly thereafter, Ms. Heard was deposed in this action in January 2022. Following her testimony, counsel determined that a deposition of Warner Brothers was needed. I think we're going to get a clue to what she said in the motions for limine that were sealed. Mr. Depp furthers meet and confer efforts and requests for a limited scope deposition of Warner Brothers. Mr. Depp contacted counsel from Warner Brothers by email on January 17, 2022 to request a further meet and confer. The parties subsequently met and conferred telephonically on or about January 19th, and Mr. Depp's counsel explained the need for a deposition of Warner Brothers to explore Ms. Heard's involvement in Aquaman 2 and any damages or lack thereof in order to prepare for trial and prepare a full damage analysis. Counsel for Warner Brothers indicated that she would consult internally and with her client. Counsel subsequently met and conferred again on or about January 21. During this meet and confer calls, counsel for Warner Brothers proposed providing a declaration that confirmed that Ms. Heard had suffered no adverse consequence as a result of any conduct by Mr. Depp in lieu of deposition testimony. Mr. Depp's counsel responded that such a declaration would be insufficient and likely would not be accepted or admissible in the Virginia court. It would be considered hearsay, I imagine. Also, on January 21, counsel for Mr. Depp provided counsel for Warner Brothers with a modified and narrowed list of proposed deposition topics and documents by email with an offer for further discussion. Counsel for Mr. Depp followed up again with counsel for Warner Brothers on several occasions by email and was advised that Warner Brothers was consulting with its client. On or about February 3rd, counsel for Warner Brothers sent counsel for Mr. Depp and for Ms. Heard by simultaneous email a letter stating in part as follows. To avoid substantial burden of Warner Brothers deposition, whose employees are still largely working remotely because of the continuing COVID-19 pandemic, Warner Brothers is willing to serve the parties with a sworn declaration setting forth the following facts. Any delay in Warner Brothers picking up Heard's option for Aquaman 2 was due to creative issues in casting Heard in the role for Mir for Aquaman 2, which were communicated to Heard's agent at the time. Any delay in Warner Brothers picking up Heard's option for Aquaman 2 was not due to Heard's dispute with Depp or any of the allegations in this lawsuit. Warner Brothers would not have paid Heard more money on Aquaman 2 even if Heard had had more time to attempt to negotiate. Doesn't sound like she's gotten any damages here. Counsel for Depp responded the same day via email to explain that the offered declaration was not sufficient as follows. We are receipt of your letter today requesting what Warner Brothers proceed to declaration in lieu of deposition testimony. We fully appreciate your client's status as a third party and have no wish to cause unnecessary expense or inconvenience. In light of the content of your letter, we will consider whether we can further narrow or withdraw some of our document requests, and we are open to further refinement of the deposition topics we have proposed. However, based on our understanding of Ms. Heard's contentions in this action, we believe evidence from Warner Brothers is essential to prepare our case for trial and to address Ms. Heard's anticipated contention at trial that she suffered substantial monetary damage as a result of the conduct she seeks to attribute to Mr. Depp. Moreover, we do not believe that the declaration you propose would be acceptable or admissible in the Court of Virginia, particularly in absence of cross-examination of the declarant. Be hearsay. Amber Heard would have the right to question them on a stand. Ms. Heard's proposed stipulation and unacceptable conditions. Whoa. Presumably, as a result of behind-the-scenes pressure by Warner Brothers, Ms. Heard's Virginia counsel subsequently offered a stipulation. However, Ms. Heard's proposed stipulations included conditions that were entirely unacceptable to Mr. Depp, including an agreement that neither party could even mention Aquaman 2 at trial, and the further restriction that Mr. Depp could not mention at trial other things. Ms. Heard's proposed stipulation included the following limitations on the party's ability to present evidence at trial and seek discovery. So apparently Depp feels there's some collusion going back and forth behind the scenes with Heard and Aquaman 2, and who knows what she claimed in her deposition. Well, we may hear later in the unsealed documents. The parties agreed that neither Mr. Heard nor Mr. Depp will include at trial any reference to Aquaman 2 for any reason, including but not limited to any evidence or references supporting or disputing Ms. Heard's damages as it relates to her counterclaims. The parties agree that neither Ms. Heard nor Mr. Depp will seek any additional discovery regarding Aquaman 2 for any reason, including but not limited to agreeing not to depose non-party Warner Brothers Entertainment Incorporated or seek any information related to Aquaman 2 with WME, that's her agent, or any of Ms. Heard's current or former agents and publicists, and will not question Ms. Heard, any of Ms. Heard's experts, or any fact witnesses regarding Aquaman 2 in either deposition of trial. Well, that's just insane. The whole thing about her $100 million. Since a major argument against the plausibility of Ms. Heard's damages is that she remains attached to Aquaman 2, and the fact most obviously being incorporated into any analysis of her claimed damages and presentations of evidence at jury. Ms. Heard's proposed stipulation was an obvious non-starter for Mr. Depp, and Mr. Depp rejected Ms. Heard's proposed stipulation. Ms. Heard's subsequent interrogatory responses under penalty of perjury late February 9th, 2022, mere hours after offering her stipulation, Ms. Heard served sworn interrogatory responses in which she asserted as follows, and we're not allowed to see those. But I have a feeling she's putting some blame on Warner Brothers. Warner Brothers' threat to give harmful testimony against Mr. Depp and Mr. Depp's final meet and confer efforts. On Thursday, February 10th, counsel for Mr. Depp met and conferred telephonically with counsel for Warner Brothers. During that call, Mr. Depp's counsel explained that Ms. Heard's condition for her stipulations were unacceptable and that a short deposition of Warner Brothers was necessary, largely to memorialize in the form of admissible testimony the factual assertions stated in counselor's letter. Counsel for Warner Brothers asserted that Mr. Depp had been given a gift as a result of Ms. Heard's proposed stipulation, and that Mr. Depp's counsel should be careful what you wish for, threatening that if forced to give a deposition, Warner Brothers would give testimony damaging or embarrassing to Mr. Depp. Mr. Depp's counsel responded by reiterating that a deposition was needed, but agreed to further explore a possible stipulation with Ms. Heard's counsel. Mr. Depp's counsel requested that in the meantime, Warner Brothers identify a person most qualified and propose convenient dates for a short deposition. Mr. Depp subsequently offered a counterproposal to Mr. Heard's stipulation, which Ms. Heard's counsel ignored. On February 16, 2022, Mr. Depp's lead Virginia counsel received an unsolicited telephone call from Warner Brothers chief counsel Wayne Smith, urging Mr. Depp to abandon any deposition of Warner Brothers and warning that Warner Brothers representatives would say bad things about both Mr. Depp and Ms. Heard if a deposition took place. When Mr. Depp's counsel did not accept, Warner Brothers representatives warned that Warner Brothers would move to Quash. On February 17, 2022, Mr. Depp's counsel received a final communication from Warner Brothers outside litigation counsel threatening a motion to quash. Counsel for Mr. Depp responded the same date, rejecting Warner Brothers' arguments, explaining once again the reasons a short deposition is needed and urging Warner Brothers not to waste the party's time and money and useless motion practice. No response was received from Warner Brothers counsel, and the motion was filed the following day. So Warner Brothers did file a motion to quash it, and this is obviously what Johnny's answering. Mr. Depp's proposed narrowed parameters of a person most qualified deposition. Mr. Depp has repeatedly offered to narrow and refine the PMQ topics throughout the course of the meet and confer, but has run into a solid wall of Warner Brothers' outright refusal to produce anyone to testify on the topic. Nonetheless, Mr. Depp's final proposal for PMQ topics are set forth below and are reflected in our amended subpoena from February 22, 2022. Any of your internal discussions as to whether to release or terminate Ms. Heard from Aquaman 2, the reasons for any release or termination of Ms. Heard from Aquaman 2, any negotiations or communications with Ms. Heard or her agents regarding her release or termination from Aquaman 2. I think these are important subjects right here because these are all done after her deposition and they have the same theme: release or terminate, release or terminate, release or terminate. And they would have got that from her deposition, I believe. Any negotiations or communications with Ms. Heard or her agents regarding her compensation for Aquaman 2. All information regarding the decisions to cast and keep Ms. Heard in Aquaman 2. Any reduction in Ms. Heard's role in Aquaman 2 as a result of negative publicity related to Mr. Depp. All reasons for any reduction in Ms. Heard's role in Aquaman 2. The impact, if any, of publicity relating to the relationship between Mr. Depp and Ms. Heard on whether to cast or release Ms. Heard from Aquaman 2. They're saying Aquaman 2 a lot here. The impact, if any, of publicity surrounding any statements by Mr. Waldman regarding Ms. Heard or whether to cast or release Ms. Heard from Aquaman 2. To the extent not covered by the preceding topics, the casting of Ms. Heard in Aquaman 2. Any creative concerns and continue to cast Ms. Heard? Any creative concerns regarding Ms. Heard's performance in the original Aquaman? And we got that. All non-privileged facts supporting so it is non-privileged, supporting the factual assertions contained in the letter from your counsel to Mr. Depp, that any delay in Warner Brothers picking up Heard's option for Aquaman 2 was due to creative issues in casting Ms. Heard. All non-privileged facts supporting the factual representations contained in the letter from your counsel to counsel for Mr. Depp and Ms. Heard on February 3rd, 2022, that Warner Brothers communicated to Heard's agent at the time there were creative concerns with continuing to cast Heard in the role of Mirror for Aquaman 2, the subject of which were communicated to Heard's agent. And yet we heard her testimony that Amber Heard should be a flying star after that. All non-privileged facts supporting the factual representations contained in the letter from your counsel to counsel Mr. Depp that Ms. Heard on February 3rd, 2022, that Warner communicated to Heard's agent at the time there were creative concerns with continuing to cast Heard in the role of Mirror for Aquaman 2, the subject of which were communicated to Heard's agent. All non-privileged facts supporting the factual representations contained in the letter from your counsel to counsel for Mr. Depp and Ms. Heard on February 3rd, that Warner Brothers would not have paid Heard more money on Aquaman 2. So Depp's issues with the trial or Mr. Waldman's statements had nothing to do whether she got more or less money or the same amount. All non-privileged facts supporting the factual representations contained in the letter from your counsel to counsel for Mr. Depp and Ms. Heard on February 3rd, that any delay in picking up Heard's option for Aquaman 2 was not due to Heard's dispute with Depp or any of the allegations in the lawsuit. It is represented that the motion be denied in its entirety and the compliance with the subpoenas be directed at minimum in conformity with the revised scope of Mr. Depp's amended subpoena on the topics listed above, all of which are clearly relevant and appropriate in exploring and establishing Ms. Heard's complete lack of damages. The Warner Brothers argument that it should not have to produce documents is frivolous. Mr. Depp is not seeking documents at this time, merely a short deposition. Warner Brothers arguments based on relevance are frivolous. Incredibly, Warner Brothers' motion is primarily based on relevance. Warner Brothers argues that his deposition is not relevant and that is harassment for Mr. Depp to seek a deposition of Warner Brothers to obtain discovery pertaining to completely undisputed facts. Warner Brothers knows quite well its arguments are specious and blatantly misleading. In the first place, as Warner Brothers counsel well knows, Ms. Heard's stipulation was unacceptable, and the deposition of Warner Brothers does not relate to undisputed facts. Quite the contrary, it relates to the matters that are very much in dispute, whether Ms. Heard's career prospects were harmed by the counterclaim statements, the Waldman's 3 statements. Moreover, and more fundamentally, the relevance and appropriateness of a deposition of Warner Brothers under the circumstances of this case could not be clearer. Ms. Heard is alleging $100 million in damages to her career. Her relationship with Warner Brothers and her role in Aquaman 2 project are directly at issue. Under these circumstances, Mr. Depp's right to take discovery from Warner Brothers is not a close call. The scope of discovery in California is broad, as set forth in Civil Code Procedure 2017-10. Any party may obtain discovery regarding any matter not privileged that is relevant to the subject matter involved in a pending action, or reasonably calculated to lead to discovery of admissible evidence. Moreover, California courts give the discovery statutes a liberal construction so as to uphold the right to discovery wherever possible. Information will be found relevant to the subject matter if it might reasonably assist a party in evaluating the case, preparing for trial, or facilitating settlement. Here, the proposed deposition topics are all appropriately tailored to the issues of this action and are directly relevant for resistance. Mr. Depp seeks to explore a deposition whether there was any delay or any other controversy in casting Ms. Heard in Aquaman 2, and if so, the reasons. Mr. Depp seeks to explore at deposition the reasons for reduction in Ms. Heard's role, if any. See, they're taking a lot of this from something she said in her deposition. And Amber blames everybody. It is no answer for Warner Brothers to argue that it should be entitled to submit a hearsay, uncross-examined declaration instead of deposition testimony, since such declaration would be useless at trial and would not enable Mr. Depp to fully explore the myriad issues involved through questioning a witness. Nor is it an answer for Warner Brothers to argue that Ms. Heard has offered to eliminate Aquaman 2 as an issue in this case. There is no agreement on that issue, and Mr. Depp is obviously entitled to explore it in discovery and present evidence at trial that Ms. Heard has not suffered any adverse consequences as a result of the counterclaim statements. The fact that Ms. Heard has never been fired from Aquaman 2 is directly relevant to the issue of damages. Mr. Depp is clearly entitled to explore the lack of damage to Ms. Heard's involvement in Aquaman 2, not to mention any of Warner Brothers' creative concerns regarding casting her, since all of those issues are relevant to any damage analysis. In short, the standard for discoverability is easily satisfied. Mr. Depp has no desire to unnecessarily burden a third party with discovery and has bent over backwards to accommodate Warner's. But this deposition is vitally important, and Warner Brothers' apparent argument that the information sought does not meet the test for discoverability is not merely meritless, but outright frivolous. Warner Brothers' arguments based on confidentiality are unfounded, and in any event, the discovery sought is vitally relevant and outweighs any countervailing considerations. As a fallback argument, Warner Brothers, with no supporting evidence whatsoever, the discovery sought implicates proprietary business information. This argument offers no basis to refuse to produce a PMQ to testify regarding the narrowly tailored topics at issue. First, Warner Brothers has failed to meet its burden of establishing as a threshold matter that any confidential information is implicated. The initial burden falls to the party asserting a confidential interest in establishing the existence of that interest, which Warner Brothers has failed to even attempt to do beyond citing generic authorities on confidentiality in a 2-paragraph argument in its brief. Indeed, Warner Brothers identifies no specific confidential information that is at issue, nor does it present any evidence regarding the seriousness of any supposed invasion of privacy. And in any event, WBE's arguments are entirely speculative, so it has not yet been deposed, and no questions have been posted to it. Second, if Warner Brothers has met its initial burden, which it clearly has not, the information sought is not merely relevant, but directly so. Indeed, it is difficult to imagine more relevant or appropriately targeted discovery given the nature of Ms. Heard's allegations. Any confidentiality interest is far outweighed by Mr. Depp's need for information sought to prepare to dispute at trial Ms. Heard's claims for $100 million in damages. Deposing Warner Brothers is the only reasonable course for Depp to take, and in any case, there is a protective order in effect in this action, and Warner Brothers is free to designate its testimony as confidential under the protective order, which I think is why we didn't see any subpoenas uploaded at Fairfax. Warner Brothers should be sanctioned. This motion should never have been filed, and Warner Brothers' arguments are patently lacking in substantial or any justification. Pursuant of Civil Code 1987.2, the court may, in its discretion, award the amount of reasonable expenses incurred in making or opposing the motion to quash, including reasonable attorney fees. If the court finds that the motion was made or proposed in bad faith and without substantial justification. In addition, Code of Civil Procedures provides that misuses of discovery process include making or opposing unsuccessfully and without substantial justification a motion to compel or to limit discovery. And to the extent that the motion is characterized as a motion for a protective order, Code of Civil Procedure provides that the court shall impose a monetary sanction against any party, person, or attorneys who unsuccessfully makes or opposes a motion for a protective order, unless it finds that one subject of the sanction acted with substantial justification or that other circumstances make the imposition of the sanction unjust. The motion is not supported by a single meritorious argument. Sanctions are appropriate. Conclusion. For all foregoing reasons, Mr. Depp respectfully requests that the motion is denied in its entirety, for Warner Brothers to be ordered immediately to produce its person most qualified for deposition, and that Warner Brothers be sanctioned in the amount sufficient to compensate Mr. Depp for the reasonable expense incurred in preparing this opposition and supporting papers in the amount of no less than $7,327.50. And that's pretty much it. We do have a declaration from Samuel who is saying that he did meet and confer. He did all these things he was supposed to do. Ms. Heard served her disclosure of expert witnesses to Mr. Depp's counsel on or about January 11th. There's all kinds of all these exhibits are attached that they're referencing. She was deposed in the action on January 22. I was present during portions of Ms. Heard's deposition, and following Ms. Heard's testimony at deposition and in view of other disclosures made by Ms. Heard in this case, it was determined by Mr. Depp's counsel that a deposition of Warner Brothers was needed. She must have been thrown Warner Brothers onto the bus. So he contacted, and this is the process he went through, and how he modified his list. And I don't think we need to read it again because it's pretty much restated. On February 9th, she was still served interrogatory responses. The true and correct copy of excerpts from her interrogatory stuff is attached in Exhibit 7. I think that's been redacted. On or about February 10th, I met and conferred telephonically. We knew that. So what we're interested in is if there's an Exhibit 7. So watch your eyes, guys. We got Exhibit 1, which is the subpoena. I'm scrolling fast because we've already known what they've done with that. It won't let me go past pages, I don't think. No, it won't. So I have to scroll down, sorry. In fact, you know what? I'll give you guys a break while I'm scrolling. I'm looking for attachment 7 to see if I previewed this before I got on, and I didn't see it go up that far. So I'm having a feeling they would have left them out. There's several of the subpoenas that they went back and forth on. There is a copy of the stipulation that they decided not to go with, but we've already read that. Exhibit 7. Just for transparency, Exhibit 7, under seal. We don't get to see it. She said something in her deposition. She said something that warranted them to push this hard to get Warner Brothers to be deposed. So Warner Brothers filed their quash motion to not have anything to do with this. Depp has now answered. Now we're going to go to Warner Brothers' final reply. The hearing's been moved up to March 3rd. It's not too many pages, don't worry. Introduction. Well, we don't have to do all this. Plain Depp's opposition papers do not accurately portray the facts or the law. While replete with baseless and incendiary accusations meant to create the false impression of an attempt by Warner Brothers to evade the judicial process, they failed to rebut the critical fact that defendant Amber Laura Heard has attempted to withdraw the very claim that provided plaintiffs ground for seeking Warner Brothers' deposition in the first place. With the purpose of the deposition obviated, it would be a needless and wasteful burden on the time and resources of all parties involved to proceed. To that end, at the court's suggestion, Warner Brothers recently sent the parties a draft declaration setting forth the material and undisputed facts that precipitated the withdrawal of defendant's claim. So basically, in that stipulation, she says, look, if we both stipulate to this, I'm going to withdraw any damages a claim. So in other words, her $100 million was going to be reduced. Any damages a claim that might have involved Aquaman. Well, she didn't have any damages claim. While Warner Brothers is hopeful that this will finally lead to a resolution, the parties have not yet reached an agreement. Warner Brothers respectfully submits that if plaintiff and defendant fail to proactively collaborate on a stipulation that would ultimately conserve everyone's resources, Warner Brothers should be shielded from any further abuse of the subpoena process by a protective order. Warner Brothers is not a party to this litigation, and simply put, does not have a dog in this fight. Yet plaintiff opposition falsely claims that Warner Brothers has sought to avoid a deposition by making threats to say bad things. This is a mischaracterization. The reality is that if plaintiffs are allowed to proceed with a deposition of Warner Brothers, its witness will be put in the crossfire of a contentious interpersonal dispute in which it has no involvement. Depositions also take time, cost, money, and distract witnesses from their work. When a witness' testimony would not resolve any factual dispute, there is no justification for inflicting this stress and burden upon anyone, especially a non-party. Well, as far as saying bad things, this is only about Amber Heard's counterclaim. So this isn't about Fantastic Beasts or their other working relationship with Johnny. Plaintiff's opposition also groundlessly speculates without evidence that Warner Brothers pressured or coerced defendant into dropping her damages claim based on Aquaman 2. This is provocative insinuation is not only insulting, it's untrue, and it has been expressly refuted by defendant's own counsel. Well, this must have come out of her deposition, right? Pressured or coerced defendant into dropping her damages claim based on Aquaman 2. That statement could only have been made or jumped to because of her deposition. Finally, plaintiff's request that Warner Brothers be sanctioned for filing this motion is absurd. Warner Brothers has already produced documents in response to the document subpoena, met and conferred with counsel numerous times, and transparently offered, both before the filing of this motion and after, to provide a sworn declaration setting out the testimony the parties can expect as an alternative to imposing the burden of deposition. But again, they can't cross-examine a declaration in Virginia. That wouldn't be acceptable. When Warner Brothers' extensive informal attempts to resolve the discovery dispute failed, Warner Brothers filed its motion for the first available hearing date and then readily agreed to plaintiff's request to stipulate to accelerate the hearing. This is not the conduct of a non-party that has ignored a subpoena or acts as if they are above the law, as plaintiff counsel incorrectly claims. Plaintiff should withdraw his request for sanctions. However, if he does not, the request for sanctions should be rejected by the court, given Warner Brothers demonstrated good faith in bringing this motion. For reasons below set forth, Warner Brothers respectfully requests that the court grant motion to quash or an alternative issue a protective order. Well, first they were fighting the protective order. Now they want it again. Warner Brothers has sent parties a proposed declaration that they can stipulate to use at trial in lieu of deposition testimony. At the court's suggestion, during the informal discovery conference held on February 25th, Warner Brothers prepared a draft declaration addressing the facts related to defendant's damages claim that she offered to withdraw in lieu of providing the same testimony through a deposition. Warner Brothers has asked both parties to confirm their agreement that they would stipulate to the admissibility of Warner Brothers' declaration as evidence at their upcoming trial in Virginia. Well, I would say this makes no sense, because certainly if Amber Heard's claiming she's losing work and she's not losing work, their deposition is pretty important. So this is what they are stipulating to. Amber Heard was cast in both the film Aquaman and its sequel, Aquaman 2, and was paid for her services on both films per her contract. True and correct copies of her talent option agreement, that's important, dated September 21st, as well as March 24th, 2017 letter exercising the option for Aquaman under the option agreement, and June 3rd, 2021 letter exercising the option for Aquaman 2 under the option agreement. And as I recall, that's pretty close to when filming had started or had already started. Ms. Heard did not suffer any adverse employment action by Warner Brothers in connection with either Aquaman or Aquaman 2 because of any of the allegedly defamatory statements by John C. Depp or Adam Waldman. They're alleged in her counterclaim. The counterclaim statements, Ms. Heard's compensation for Aquaman or Aquaman 2 was not reduced because of the counterclaim statements. Well, that's important for a jury to hear. That's really important. Ms. Heard filmed Aquaman 2 between July 15th, there it is, July 15th and July and 2021. So let's just, June 3rd, they didn't pick up her option to start filming. Like a month earlier, she still didn't know if she was going to be in the film. Any alleged delay in picking up Ms. Heard's option from Aquaman 2 was due to creative issues in casting Ms. Heard in the role for Mira for Aquaman 2, which were communicated to Ms. Heard's agent at the time. Doesn't exactly match her testimony, does it? Any alleged delay in Warner Brothers picking up Ms. Heard's option for Aquaman 2 was not due to Ms. Heard's dispute with Mr. Depp or to any of the allegations in this lawsuit, specifically including the counterclaim statements. Warner Brothers would not have paid Ms. Heard more money in Aquaman 2, even if Ms. Heard had more time to attempt to renegotiate her contract. She only had a month. At the time this reply was filed, plaintiff and defendant had not yet reached agreement with respect to the proposal. The law is clear that the parties can stipulate to the admissibility of the declaration from Warner Brothers and facts set forth therein for their incoming trial. At the final pretrial conference, the court and counsel of record may consider any of the following: the possibility of obtaining stipulations of fact, including but not limited to admissibility of documents and any such matters. Well, yeah, Amber Heard's team put a stipulation document together, and Johnny said, no, you're still contending you have damages, and I have proof that you're working and employed. You don't have damages, so I'm not going to stipulate to this. And I am going to talk about Aquaman 2 a lot. Consequently, Warner Brothers offered to set forth a sworn declaration that it would testify to at deposition directed to defendant's withdrawal damage claim would be accepted by the parties to resolve this motion. This is especially true given that the discovery cutoff is only a week away. Yeah, because they intentionally are dragging their feet. And this is the most expedient and least burdensome way to secure the testimony for the upcoming trial. So look, Depp team was fighting hard to get this testimony in for trial. Plaintiff, that's Johnny, does not dispute that the Amber Heard offered to withdraw her damage claim based on Aquaman 2. But they had to show that she had no damages. So the fact that she was still working is important. If Warner Brothers' continued effort to resolve this motion fail, including through its offer of a sworn declaration, Warner should be protected from burdensome deposition premised entirely on undisputed facts directed to withdrawn claim. A withdrawn claim. We've never seen any of this. I didn't see it in the unsealed documents either. When first served with the deposition subpoena and document subpoena, Warner Brothers produced the contract between Warner Brothers and defendant, as well as 2 option letters for the motion pictures, Aquaman and Aquaman 2, demonstrating that there was no dispute that defendant was cast in both Aquaman and Aquaman 2 and paid for her services per her contract. When plaintiff's counsel continued to insist that a deposition of Warner still go forward, Warner said sent the parties a meet and confer letter transparently setting out the testimony they could expect and offering to submit a sworn declaration in lieu of deposition testimony. Plaintiff admits in his opposition that the defendant then did in fact to offer her withdrawal damage claim based on Aquaman 2. Defendant has not made a damages claim based on Aquaman. I find this interesting, and I wonder if this came out, since we don't see it in the sealed documents, I wonder if it came out in settlement talks that we read about, but are staying sealed. Despite defendant's offer to withdraw her damages claim based on Aquaman 2, which wasn't $100 million, plaintiff's counsel still insisted that a deposition of Warner's go forward. In fact, plaintiff's counsel never even attempted to work out a stipulation in response to defendant's offer to withdraw her damages claim, and instead continued to pursue a deposition of Warner. It was only after counsel for Warner Brothers pressed plaintiff's side during a meet and confer call as to why it had never tried to work out a stipulation with defendant to withdraw her damages claim, the plaintiff's counsel responded to defendant's offer with a laundry list of additional demands that defendant refused to accept. Well, yeah, she didn't lose $100 million. And I would love to know what this laundry list of additional demands is and how Warner Brothers knows about it. While Warner understands that the parties are continuing to negotiate regarding Warner's proffered declaration, in the event that the parties fail to reach an agreement, Warner Brothers should be protected from further unnecessary exploitation of the discovery process. Warner Brothers should not have to sit for an unnecessary deposition touching on sensitive business information directed to withdraw claims. Warner Brothers met and conferred with plaintiff's counsel on numerous occasions and explained that it made no sense to proceed with a deposition of Warner when defendant had already offered to stipulate to withdraw her damages claim based on Aquaman 2. Well, she got what, $2 million, maybe $4 million from Aquaman? So she was going to claim $96 million? Because the result will be hours of questioning from counsel for both plaintiff and defendant, in which both parties' counsel would likely attempt to solicit damaging and irrelevant information about the other for use in a public trial. That's not really true, because Depp had already, in the last motion, narrowed down the questions they want to ask. Plaintiff's counsel completely mischaracterizes its conversation with counsel for Warner's, claiming Warner's counsel threatened to say bad things about plaintiff if the deposition went forward. This could not be further from the truth. Warner has sought through extensive meet and confer efforts in its offer to submit a declaration in lieu of testimony to resolve this matter without acceding to plaintiff's attempts to seek irrelevant but highly confidential, sensitive, and proprietary business information that he imagines could be somehow used against defendant and vice versa. I don't know about that. Those questions seem pretty narrow. Plaintiff is simply not entitled to this information under the law establishing relevancy required for discoverable information. California courts have held that the discovery relevance to the subject matter of the pending dispute and whether the discovery appears reasonably calculated to lead to the discovery of admissible evidence is balanced against the corporate right of privacy. Oh, they're going to be getting a lot of information. Oh, yeah. Warner says a neutral non-party with no side in this litigation should not be forced into the position of creating immaterial sound bites about confidential aspects of the business. Yeah, but you were talking with Amber's team behind the scenes, that's for sure. That's how that stipulation came about. That is not the purpose of discovery. This is especially true in a highly publicized case, the trial of which is to be subject of widespread attention and will be publicly televised. Yes. Thank God. The potential harm to Warner's is unjustified and wholly unnecessary. Indeed, the only ostensible purpose for Warner's deposition has been eliminated. Plaintiff's counsel attempt to malign Warner for not wanting to unnecessarily be put in the middle of the parties' dispute is entirely unwarranted, and its argument should be rejected if Warner's continues efforts to resolve this motion without the court's involvement and fail. I don't think accepting Amber Heard saying, you know what, I'm not going to claim the damages against Warner Brothers. We'll never mention Warner Brothers. We'll never mention Aquaman 2. I'll drop all those claims, and instead of like the $4 million I got, I'll now claim $96 million. I don't think that was going to be as effective at trial without Warner Brothers taking the stand that they did, that they were forced to. Plaintiff's claim for sanctions is supported only by conclusory arguments, not evidence. This is a fabricated version of events, and there's no basis for sanctions. There's no dispute that Warner Brothers produced defendant's contract and letters exercising her option for Aquaman 2. Demonstrating defendant was cast in both films. Paid pursuant to the terms of the contract. We already covered those footnotes. Warner Brothers then sent a meet and confer letter transparently setting forth the testimony the parties would expect from Warner Brothers and offered to submit a sworn declaration. Again, this declaration is not admissible in Virginia. And luckily, the California courts has to consider that. Finally, after multiple attempts to meet and confer, plaintiff's counsel failed, and Warner Brothers filed this motion for the first available date. Warner Brothers agreed to stipulate to move the hearing on the motion up 4 months because it was supposed to be held way after the trial. Finally, at the court's suggestion, Warner even prepared a draft declaration and sent it to the parties. Sanctions cannot be imposed where there is lack of evidence or misconduct or bad faith. Here, plaintiff is not and cannot demonstrate what Warner Brothers engaged in any misconduct or bad faith. For the foregoing reasons, the court should grant Warner Brothers' motion to quash the subpoena. So what's come out of this so far? Surely something came out of that deposition suggesting that Warner Brothers had let her go, and it was Johnny Depp's fault via Adam's statements. But Warner's saying, not so fast. Here's our declaration. Well, a declaration is not admissible. And the fact that she might be dropping her damages from Aquaman 2, because she actually did get hired, and she did do the movie, and she did get paid what I thought was announced at $4 million. She's going to turn around and try and throw $96 million at the jury, when clearly a blockbuster film that made Warner Brothers $1 billion on the first round would prove that they're still using her, and she has no damages. And then we get into the court order. Hearing date was March 3rd. There's notice of the ruling. March 3rd at 10 a.m. The hearing was held in Department 19 in Los Angeles on non-party Warner Brothers Entertainment's motion to quash plaintiff's deposition subpoena for personal appearance and production of documents and or a protective order. These lawyers were there. Those lawyers were there. Don't see and lawyers for Amber Heard. Having considered the papers filed in support of and in opposition to the motion and hearing oral argument, the court rules as follows. Warner Brothers' motion is granted in part and denied in part. Warner Brothers' motion to quash is denied, but Warner Brothers' motion for protective order is granted as to a 2-hour limitation for John Depp and a 1-hour limitation for Amber Heard, not including discussions regarding objections. So in other words, when they're videoing this deposition, if one side objects, the clock stops, they discuss. When they go back to questioning, the clock starts again, and the subject area is explored. The Warner Brothers deposition will be conducted on or before March 17th, unless extended by stipulation of the parties. A true and correct copy of the order is here. Here it is. It's filed. Order granting non-party motion in part. Granted in part, denied in part. The motion quash is denied, but the motion for protective order is granted as to a 2-hour limitation for Don Depp and a 1 hour for Amber Heard. This was this is what I'm talking about, this massive legal battle that was going on for years in other courts outside of Fairfax. That's important to memorialize and research and bring forward that this trial just didn't happen in 8 weeks. It took a lot getting there. And we see this introduced in the unsealed documents, which will be in part 2 of this. It gets revisited quickly in part 2. and it'll be a shorter video. That's where we are now. So again, this is the battlefield for pretrial motions, and that's my ongoing series. And I want to thank you all. And all these documents I had to pay for, and I will try and make them available to you in links, but they sometimes expire, and that's the best I can offer. So thanks, everybody. Have a great day, and look forward to part 2. Like, share, subscribe, comment. I try and answer comments twice a day as best I can, and I really appreciate you all. Thank you.